When you really boil it down, modern medicine comes down to a conversation, that crucial moment between a doctor and a patient about what to do next. And right there, that's where consent happens. But how we think about consent today, well, it's the result of a massive power shift, a real drama driven by the law. For the longest time, the doctor was firmly in the driver's seat, no question. But some huge, landmark legal battles have totally redrawn the map of that relationship. They've changed the fundamental duties of a doctor and, just as importantly, the rights of a patient. And that really gets us to the core question we're digging into here. When it comes to a medical decision, who actually gets the final say? To figure that out, we've got to go back in time. So let's rewind a bit. Let's start in an era where the whole doctor-patient thing was, well, pretty paternalistic. The belief, both in society and in the courtroom, was that the doctor's judgment was everything. Their main job was to do what they decided was best for you. Two court cases from the 1950s really locked this idea in place. First, in '54, a BBC broadcaster was worried an operation could damage her voice. The surgeon promised her there was no risk, even though he knew there was. Her voice was damaged, but the court sided with the doctor, saying he basically lied, quote, for her own good. Then, just a few years later, the famous Bolam test came along. And this quote from that 1954 case, wow, it just perfectly captures the thinking back then. The judge essentially said, hey, we're not going to blame a doctor for doing what other wise doctors would have done. The standard of care was set by other doctors, not by a patient's right to know the truth. The Bolam test made this official. It basically said a doctor wasn't negligent as long as what they did was backed up by a solid group of their peers. And here's the key thing to get. The medical profession got to judge itself. The patient's view on what they needed or wanted to know, it just wasn't really part of the legal equation. So for more than 50 years, the Bolam test was the law of the land. It was the standard. But then, in 2015, a single case that went all the way to the UK Supreme Court set off an absolute revolution in medical law. The case was brought by Nadine Montgomery. Her son was born with severe disabilities after complications during his birth. Complications she was never warned were a specific risk for her. Her case completely flipped the script, shifting the entire legal standard from being about the doctor to being about the patient. It was a seismic change. And believe me, the shift was huge. You can see it right here. Under Bolam, everything was focused on the doctor. The question was, what would other doctors do? But the Montgomery test turns that completely on its head. Now the focus is the patient. The standard isn't what doctors think is important, it's about what this specific patient would want to know. We went from a doctor knows best model to a partnership. At the heart of all this is a new idea called material risk. And it's not just about the tiny percentages of something going wrong. A risk is now legally material if it's something that would matter to you, the patient. And that's determined in two ways. So first, there's what's called the objective test. What would any reasonable person in your shoes want to know? But then, and this is the game changer, there's the subjective test. What does the doctor know, or what should they know about you as an individual? It forces a real conversation, a real dialogue, to find out what truly matters to the person sitting in front of them. Lady Hale, one of the judges in the case, just nailed it with this quote. The law now explicitly protects a person's autonomy, your freedom to decide what happens to your own body. And that means doctors don't just have to tell you about the treatment they recommend, they have to talk about the other reasonable options too. Okay, so this legal revolution was a massive win for patient rights, right? Everyone celebrated. But like any huge change, it had some, well, unintended consequences. And it led to this growing, really complex phenomenon called defensive medicine. So what exactly is defensive medicine? It's pretty simple, actually. It's when doctors and clinicians start changing how they practice, not because it's better for the patient's health, but because they're trying to protect themselves from getting sued or having a complaint filed against them. And this fear, it's not just in their heads. Look at this number. In the first 5 years after the Montgomery ruling, payments for lawsuits about informed consent, about failing to warn patients, shot up by a staggering 177%. The legal and financial pressure on doctors and hospitals became incredibly real, overnight. So what does this actually look like in a hospital or a doctor's office? Well, it can mean ordering way more tests than are actually needed, just in case. It means spending a huge amount of time on paperwork to cover yourself. It might even mean doing a C-section, not for a medical reason, but because it feels like the safer option legally. But it's not just about fear of getting sued. research shows it's a whole mix of things. Intense pressure from patients and families, what some call a growing blame culture, where every bad outcome has to be somebody's fault, and maybe most sadly, a breakdown of that core trust that used to define the doctor-patient bond. And this quote from a midwife, it just hits home. She said, "It is almost like, don't look after the woman, just make sure your paperwork is immaculate." It perfectly captures that feeling that the top priority has shifted from caring for the person to creating a perfect paper trail. And that's causing a lot of frustration and burnout. So, where do we go from here? The Montgomery ruling put the patient at the center of their own care, which is absolutely the right thing. But building a true partnership takes more than just following the new rules. It means we have to move beyond a culture of fear.
Experts are now talking about a totally new model for consent, one that starts by truly personalizing risk, not just rattling off a list of side effects, but talking about what those risks mean for that patient's life. It's about turning a doctor's monologue into a real two-way dialogue. And it means hospitals have to create systems that actually support that conversation, instead of just treating consent as one more box to tick.
Honestly, I think the best way to wrap your head around this whole shift is the co-pilot analogy. For decades, the patient was a passenger. You just sat back and hoped you'd land safely. Now, the patient is the co-pilot. Sure, the doctor is the expert pilot who knows how to fly the plane. But the destination, the route, and how much turbulence you're willing to go through, the whole flight plan, that's something you decide on together. Which leaves us with this final, crucial question. We've got a law that empowers the patient, but it's created a culture that can push doctors toward defensiveness. So the real challenge now is, how do we build a healthcare system that's truly based on partnership and trust, not just one focused on legal protection?